Welcome back to the Lars Larson Show. It is a pleasure to be with you, and I'll get back to your phone calls and emails shortly at 866-HEY-LARS. That's 866-439-5277. Emails go to talk@larslarson.com. You can follow on Facebook at The Lars Larson Show. Mr. Byron Henry joins me now, a Dallas-Fort Worth attorney and a constitutional scholar who's filed papers and briefs in the U.S. Supreme Court. Mr. Henry, welcome to the program, and congratulations. It's quite an honor to get the chance to practice before the U.S. Supreme Court, isn't it?
Yes, it is. It's my pleasure to be with you today.
Well, so tell me this federal judge in Hawaii, and I've tried my best to understand the logic he uses to find that if the President of the United States tells foreign nationals who are not American citizens and they're not on American soil that they cannot come into our country, that somehow this either abrogates some constitutional rights they have there, which I didn't think existed, or that denying them the chance to travel here somehow violates the religious practice rights of American citizens who are already here. Can you explain to me, do you understand what this federal judge was trying to say?
Well, let's put it this way. The first order holding President Trump's executive order, the first order unconstitutional, temporarily, by the way, not permanently, but just temporarily at the first stage of the case, was a stretch. This here, I would say, borders on unprecedented. I rarely agree with President Trump on his legal analysis. His speech last night calling this unprecedented judicial overreach is pretty accurate, considering, as you said, the individuals that could not come to this country under this order, temporarily, mind you, for 90 days, which, just a side note, the visa process for people in these countries and the vetting process probably takes more than 90 days anyway. So they're not coming here in the next 90 days. So how that could harm anyone who's filing a lawsuit that they can't come here for 90 days is beyond me. But assuming they have some standing to argue that the delay is harmful, he's basically saying that because President Trump and his surrogates talked about a possible ban on a temporary ban on Muslims coming to this country back in the campaign 18 months ago, that anything he does with respect to Muslims now is suspect and is tantamount to religious discrimination. And that's basically what the federal judge says, citing evidence from Rudy Giuliani and some Face the Nation and CBS News shows and President Trump's own speeches as a candidate, mind you, not as President of the United States making policy, but just talking to potential voters, said that because he said these things, this must be a veiled attempt to discriminate against Muslims and not to protect the country. Therefore, we're going to hold that it violates the Establishment Clause because he is basically singling out a religion for disfavored treatment. And that's the sum total of the judge's logic.
And yet, Mr. Henry, aren't there specific federal laws that allow the president, and the McCarran Act among them, that say the president can, for any reason that he determines necessary to protect the country, may deny any group of people coming in? And I can imagine other groups. You could imagine a group that was centered around a religion, maybe not Islam, but there used to be white supremacist Christian groups in the United States. If they had a foreign analog, let's say you had some white supremacist Christians in Germany who said, we want to come to the United States, and the president said, that's a dangerous group. They've done some crazy things over there, and we don't want them coming over here. You could keep them out, couldn't you?
Well, not only can you keep them out, I'll go one step further. First and foremost, there's never been a court case that I'm aware of applying the Establishment Clause to immigration practices to people outside the country.
Right. That's
number one. But even more important is there is a number of federal laws in which Congress has expressly commanded that certain religious groups and religions get precedent. I'll give you one example. The Lautenberg Amendment gives preference to Soviet Jews when they were coming to this country and trying to get in. There's other federal laws that say you have to give preference to nuns, priests, and other ministers of religions when they're trying to get in. There used to be specific laws preferring religious minorities and religious persecution over non-religious reasons. And, of course, if the Establishment Clause is really the reason and the judge wants to stick to his guns, not only are you not allowed to prefer one religion over another, you're not allowed to prefer religion over non-religion. So any reference to religion at all in any immigration decision or statute would be unconstitutional, according to this judge. And, of course, we know that's not true because Congress has written innumerable numbers of references to religion and persecution and exceptions to immigration law. So either the entire immigration system Congress has set up over the last 40 years has dozens of unconstitutional statutes, or this judge has just overreached and started applying whatever constitutional provision he can find to Trump's travel ban in order to invalidate it.
Well, and that kind of policy, if that became law, say it went all the way up through the courts and the Supreme Court reaffirmed it, wouldn't it produce the kind of bizarre policy like if you went back to just before World War II and there were Jewish people trying to escape Nazi Germany and the U.S. government said, hey, we're going to give special consideration for quick, approval of Jewish peoples wanting to leave Germany or France or other countries, that would, you'd be able to say, well, no, that's giving preference to one because of religion, or Yazidis in the Middle East at a certain point in just the last few years, that would not be allowed because you'd be giving preference, say, to Yazidis over Muslims, and yet that'd be an absurd result, wouldn't it?
Of course, and not only would that be absurd, not only would that require that result, and those are absurd results, I'll go even one further and say that because you can't prefer one religion over the other or discriminate against one, that would mean preferential treatment for other countries such as Israel. If America wanted to extend special considerations to Israel, it's one of its strongest allies, by receiving its ambassador and not receiving a Muslim ambassador. A federal court could step in and say, President Trump, you are not allowed to have the president of Israel over here, the prime minister of Israel in this country, if you do not also have the leaders of these other foreign countries in this country, because that is discrimination, and it's preferring Israel over these predominantly Muslim countries, which, of course, is ridiculous, but that's the same logic that is used to come up with this order.
All right, I'm talking to Byron Henry, who's a Dallas-Fort Worth attorney and a constitutional scholar. Now, let me ask you where we go from here, because obviously the three branches of government are co-equal. One is not superior to the others. So given the fact that it seems that every time the president tries anything connected with this travel restriction, temporary as you point out, that he's going to be blocked in the courts, they'll find a judge who will do it, probably in the Ninth Circus Court, because they're the most overturned loony court in America. I know you don't want to say that, but I'll say it. So would the best process be then for the president to say, fine, thanks a lot for your opinion, but I'm going to go ahead and do it because it's necessary for national security, and you can keep on suing if you want to, but we're just going to go ahead and do it. Is there anything other than politics that would keep the president from doing that?
Well, there's a couple things the president can do within the system without thumbing his nose at the judiciary and deciding to say, I'm just going to do what I want. First of all, he can go to the Supreme Court immediately or an emergency basis, or take the normal appellate track, which in either case, this case would be sitting on the desk of the Supreme Court at a time, according to the Senate leaders, after Neil Gorsuch would be confirmed as a Supreme Court Associate Justice. So there'll be 9 justices on the court to rule on this if President Trump wants to take it to the United States Supreme Court. But the other thing you have to remember is, and this is one of the rare instances when the bureaucracy is actually it helps conservatives, which I rarely find that to be true, and that is that everybody that already has visas can come over here anyway. President Trump exempted them from the order, which means everybody else that wants to come from these countries has to get a visa, has to apply for a visa. They don't have one yet, which means as of today, their either visa applications have not been made at all, or they're in processing. Well, I can tell you, if I was the State Department, there would be the longest slowdown of processing of visas from these 6 countries until we got a ruling from the court. And there's no court decision saying you've got to process these visas in 10 days, because even under President Obama, some of these visa applications were 6, 7, 8, 9 months to get processed. So effectively, President Trump can stop the flow of new visitors from these countries in the bureaucracy legally and according to the court decision without thumbing his nose until he can get a final ruling from the Supreme Court. And that does both. It follows the rule of law and it keeps the country safe for the next 90 to 120 days.
That sounds like the great option. Mr. Henry, it's a pleasure. Thanks so much for the time.
My pleasure, Lars.
You bet. Byron Henry from Fort Worth and Dallas. Back in a moment with your calls on The Lars Larson Show.